Hello and welcome. In this video, we are going to talk about if CPC is a procedural law or substantive law. So there are two types of laws. One is substantive, one is procedural. Substantive law decides what rights and duties a person has. Procedural law decides how to enforce those rights in court, the steps, the process, and the machinery to follow. So the example for substantive law, it tells you what your rights are. Procedural law example is it tells you how to go to the court and how to get your rights. Halsbury's definition for this substantive law creates or defines legal rights and duties. For the procedural law, Hansberry's definition says provides the method or process to enforce those rights and duties through a court. There is at the outset a vital essential distinction between substantive law and procedural law, according to the Halsbury's. So they both work together, they are dependent, they are not independent. Procedural law depends on substantive law, it acts as a helper or support system to do it. Both are closely connected, and it's not always easy to draw a clean line between the two. Procedural law gives lives to the rights, substantive law creates rights, but without procedural law, those rights would be useless. Procedural law provides the remedy, the means to actually enforce a right. So there is ubi jus ibi remedium. So it means where there is a right, there is a remedy. So the examples of Indian law according to the substantive law, Indian Contract Act, Transfer of Property Act, Industrial Dispute Act, IPC, which is now BNS. Examples of procedural law, Indian Evidence Act, Limitation Act, CPC, Code of Civil Procedure, CRPC, which is now BNSS. So CPC is a procedural law. CPC does not create or take away any right. It only tells civil courts how to follow the court correct process while deciding cases. CPC is clearly a procedural adjective law, not a substantive law.